As you all remember, there was a bill that came over from the House, which we talked about, which our committee found was too broad, the way it was worded. And so this is an alternate approach. It's an approach that I think many of us discussed. And basically what it says is that any law enforcement officer who violates the statutes that we passed during the special session in the new chapter on use of force would be civilly liable for any personal injuries that somebody receives as a result of that violation. If you all remember, in that article, we passed a provision prohibiting chokeholds unless an officer's life's at risk. We passed a provision prohibiting shooting into a moving motor vehicle unless somebody's life is at risk. We required some other standards with regard to the use of deadly force, and we also passed an article relating to an officer's duty to intervene in the event excessive force is used. Each of those statutes has, I guess, standards within them, whether it's a reasonableness standard in some situations or there's certain exceptions that you can prove, for example, to use a chokehold, like if your life is at risk.
Mr. Chairman.
Can I finish and then I'll take questions?
Senator will finish.
One of the other big concerns that we heard from law enforcement about the bill last year and some of the bills that have been talked about around the country is law enforcement officers concerned about personal liability, potentially having their home or their assets at risk. This bill specifically requires a locality to indemnify a law enforcement officer for any kind of damages that were to result. So the locality would have to pay. And in my experience, that's pretty much what always happens anyway, although I've heard some localities grumbling about this. But I can't remember the last time I've heard, if ever, about a law enforcement officer having a judgment taken against them in a 1983 action and the locality didn't pay the judgment. But this makes explicit in the bill that the locality will pay for the judgment, even though the police officer can be held liable also. So the only way a law enforcement officer could have to pay something is if the locality doesn't have any money. So that's basically what the bill does. I think it's an approach that is much more narrow. It focuses on what most people care about, which is police officers, law enforcement officers, breaking rules in ways that hurt people physically. So that's basically what it's focused on, and it's basically a sovereign immunity waiver. Mr. Chairman, I'm happy to take any questions.
Okay,
Chairman.
Senator Sasslaw.
Did I hear you right that if the locality didn't have the money, then the officer would have to come up with it?
Well, or if their insurance company didn't have any money. Most localities are insured by the Virginia Municipal Legal Insurance, and I can't speak for all 400 some localities and whatever, and I can't remember that I've ever heard of a locality in Virginia never not paying some sort of judgment. But theoretically, that's theoretically possible. I think it's highly unlikely.
Okay. Any other questions of the
Mr. Chair.
Yeah, Senator Morsi.
Senator Servalite, last night during dinner, I probably had a half-hour conversation with two of the police chiefs in my jurisdiction, Hopewell and Petersburg. Can you address, because you mentioned specifically chokeholds in your summary, it's not just chokeholds, but it's other behavior by a police officer that causes injury. Is that correct?
Yes, Mr. Chairman, if it's not the law yet, it's not the law until March the 1st,
right,
but it's actions that are covered by it's the new chapter 7.1 and title 19.2. And 19.283.4 prohibits the use of an extra restraint. B prohibits the use of a firearm into a moving motor vehicle. Subsection C has to do with kinetic weapons. Then 83.5, the next code section, has to do with deadly force, and it has standards for the use of deadly force, and then a set of standards by which deadly force is evaluated by, and then section 19.283.6 has to do with a law enforcement officer's duty to intervene in cases of excessive force. And those statutes that are there right now are per se grounds for decertification, and I would submit that if somebody were to be sued for a 1983 violation these statutes that we adopted would waive qualified immunity in a 1983 action because they are clearly established rules that are in the code. And so, from my perspective, this bill doesn't really do a whole lot to change the law of civil liability, except that it requires the locality to indemnify the officer. I really don't think it is really a huge change.
Mr. Chair.
Can I just have one follow-up question, very brief?
Senator Morrissey.
So the violations that you just mentioned, the untoward conduct of a police officer, that was the total list of behavior, is that correct?
Right.
So final. So that this would not allow an individual who claims that an officer pushed him or shoved him to bring that type of action, is that right?
Mr. Chairman, the only time I think pushing or shoving could fall into it is if that somehow fell into the excessive force provisions under 19.283.6, and a push or a shove probably wouldn't get you there, is my guess.
All right, thank you.
Okay, anybody else has questions?
Oh, sorry, Obenchain.
Patron?
Obenchain.
Mr.
Senator
Chairman.
Obenchain, yeah.
All right, a couple of things. I mean, number one, just want you all to realize what this is doing. This is a repeal of qualified immunity, number one. Number two, right now, with qualified immunity and with insurance as it is, if you've got a police officer who engages in intentional misconduct, hurt somebody intentionally, or something that is clearly unconstitutional, that police officer has personal liability for it. That's a disincentive for that police officer to act intentionally or in clear violation of somebody's constitutional rights. That police officer is insured under a policy issued to the city or county, typically for $1 million. If the verdict is $10 million, the officer has personal liability for it. Under this bill, the officer has no liability for any of that conduct. Okay? So he does this with impunity, clear violation of constitutional rights, knowing that the city or county is liable for the damages. And it can be $10 million, not $1 million as is really the effective cap right now, unless the city or county did something clearly wrong. So, this is also adding attorney's fees and other damages as well. So, this is turning the American rule on its head with respect to these actions. This is creating a safe harbor for unconstitutional conduct by police officers, and I know that that is not what the patron is intending to do. I want to make sure that police officers are protected for reasonable actions that they take, and I think this would protect them, but it imposes a significant liability on those local governments as well.
Mr. Chairman.
Okay, yes, Senator Sturville.
Thank you. So let me try and be a little clearer about some things. Qualified immunity is not blanket immunity for police officers. I think there's a misapprehension in the public about what qualified immunity really is. Qualified immunity does not apply when somebody's constitutional rights are violated by a government officer if those rules are clearly established in the law. So if the rules are clearly established in the law, there's no qualified immunity. In last session, special session, we adopted a whole series of clear rules. So the effect of adopting those clear rules was to abrogate qualified immunity for violation of those rules. Okay? So this bill just simply reconfirms that in state court, you can bring an action, civil action, for violating those rules, just like you could on a 1983 action. And additionally, on a 1983 action, you can already recover attorney's fees under 42 U.S.C. 1988. This confirms the same thing. So the only difference I would submit is Senator Obenchain is correct about the indemnity piece. And perhaps there ought to be language in here about some kind of intentional, willful misconduct. not being subject to indemnity. But I would also just note, in anticipation of some of the things that might be said by people in the public, the reason I phrased it as primary employer is because sometimes police officers are subbed out, I guess, the fairest way to say it, to like banks or events or whatever, and they make overtime or get paid to wear a uniform and stand security at places. And there was some concern the way my bill was originally drafted that it would disincentivize those third parties from hiring police officers. And so I put in this language about any primary employer that employs or contracts services of a law enforcement officer, yada, 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 with or without pay, shall be liable when the violation occurred within the ordinary course of the employer's business. So, I mean, if the senator would like to make an amendment to carve out willful, malicious, intentional conduct from that, I think that there might be a discussion to be had there. That's one of the nuances of this that gets kind of complicated.
We have people here waiting to speak. Let me clarify one thing. Qualified immunity is case law in the federal system only. It has to do with qualified immunity when a law enforcement officer is sued under 42 United States Code, Section 1983. That's all it is a federal case law with regard to federal lawsuits. It doesn't apply to the state at all. Now, several people would like to speak, I believe.
Mr. Chair, before
yeah.
we get started, could I move that amendment that the patron suggested?
All right, the amendment is to, say the amendment again. Where's the amendment? Line amendment? Where?
You asking me, Mr. Chairman?
Yes, somebody. Yeah.
I think it would probably go in line 24, and Charles could probably write this better than I could, but it would say something like, provided that there be no liability for any act that was committed willfully, maliciously, and intentionally.
All right, there's a concept. I'm sure Charles can come up with some language.
Can I speak to that?
Yeah, but go ahead, Senator Obenchain.
So here is the rub, is that any good attorney can avoid that. I mean, if I'm trying to sue Officer A who committed an intentional act, and I want to make sure that I can recover, all I have to do is avoid alleging that the act was intentional. And it's all a matter of pleading. And what we're doing is simply creating a roadmap for how to pursue this without pleading yourself out of coverage. I mean, it's what we do in civil cases, other civil cases all the time, is you don't ever want to allege that somebody did something that's not covered by an insurance policy. So we're just creating the roadmap for how to do that. So
Okay, everybody understand? What he's saying is, if you put this intentional in, then there's a question of insurance coverage. Okay? But you want the language, where would it go? Which line?
Line 24, Mr. Chairman. At the end of line 24.
When such violation occurred within the ordinary course of the employer's business and was done intentionally?
No. I said provided that there shall be no liability for any act that was performed willfully.
Mr. Chairman, I would say provided that such officer did not act willfully, intentionally, or maliciously.
There you go.
Oh, didn't, okay, did not. Okay, so you keep the insurance in.
So, Mr. Chairman, and I hate to ask one more question, but what if the locality knew that the officer had a history of acting willfully, intentionally, and maliciously? Shouldn't the locality have liability then?
Mr. Chair. Evidentiary issues, yeah. Senator Sherrill.
Peterson.
Peterson, okay. Senator Peterson.
Mr. Chair, I know we could spend hours on this, and I'm certain you have speakers, and I'm looking forward to hearing from them. But once we've done that, I'm going to make a motion to have this referred to my Civil Laws Subcommittee, where and I'm at that point going to make a motion that we're going to sort of take this by and talk about it. I just don't want to see us rushing through this, needless to say, but that will be a motion I will make.
Okay. Right now we have this proviso on line 24, provided that the officer did not operate did not act intentionally, willfully, and whatever. Is that right? Is that the motion? Provided?
So moved. Yes.
Yeah, Kristen, okay. All in favor of the line amendment, say aye. Aye. All opposed, no. Motion carries. Okay. Now, there are several people who would like to speak, I'm sure. Would like to speak first? Wayne Huggins?
Good morning, Mr. Chairman. Thank you for affording me the opportunity to speak. I could talk about this at length for longer than you want me to. And we do appreciate Senator Servell giving us the opportunity to review this. For the variety of legal reasons that have already been stated, we absolutely oppose this. But I want to talk about the human element rather than the legal element. Law enforcement widely views this as yet another assault on our profession. It's impacting enormously our already low morale. In fact, I was recently told by a member of your committee that the police department, the law enforcement agency in their jurisdiction has basically backed off. In fact, they're being referred to as parking lot security because they are not out enforcing the law. They are afraid. Their morale is low. And even after having just graduated a basic academy class, we still have over 300 vacancies. So the question becomes, why do we want to keep throwing these impediments up when clearly, in our opinion, this bill provides absolutely nothing that is not already available to enterprising defense lawyers who want to sue law enforcement? So for those reasons and many, many more that I could cite, we are absolutely opposed to this. Thank you.
Yeah, thank you, Wayne. Next, who would like to speak? John Jones?
Thank you, Mr. Chairman. I'm John Jones, representing the Virginia Sheriff's Association. I'm not going to repeat what Wayne said. We endorse that. I would say this. Our turnover rates have substantially increased in the last year. Our turnover rates are hovering around 35% in some of the sheriff's offices and even more in some. It's hard to find deputy sheriffs to work, and the starting state salary is about $34,475. I've had sheriff after sheriff after sheriff and deputy after deputy say, if this qualified immunity bill passes, they're out of here. They're not going to work with everything going on and be subjected to more suits than we've got. We already can be sued. We have been sued. When we're wrong, we get sued. When we lose, this will open the door for frivolous suits, we think. So for that reason, Mr. Chairman, I would clarify one thing that's been said. The local governments do not provide liability insurance for the sheriffs. There's a $1.5 million, it's not actually a policy, but it's provided by the Commonwealth through Risk Management or Virginia Risk Policy. So we're very much opposed. I'm representing 118 of the 123 sheriffs and 9,000 deputies, Mr. Chairman. Thank you very much.
Okay, thank you. Next, who would like to speak?
Mark Segal, please go ahead.
Thank you. Can you hear me, Mr. Chairman? Mr. Chairman, can you hear me?
We can hear you.
Yes, go ahead. Thank you very much. The only thing that I'm going to say when it comes to the legality of this is that 20-something years ago in the city of Richmond, there's a case, Mark Snoop, who is a police officer, who, in my opinion, got a very sympathetic jury to the opposite of police department's views, and he received a $400,000 punitive judgment. He ended up having a mental breakdown essentially and losing his job. But what I want to talk about is another part of the human element of what's going on here. Since June 29th in Central Virginia, particularly on the Richmond Police Department, the Henrico Police Department, the Chesterfield Police Departments, and I represent Hanover County, though, and we've been on standby to assist them. These have been unprecedented times since June 29th. Our police officers in this area have endured assault, gunshots, objects thrown at them, their cars surrounded, bricks hit at their car and their heads. Officers received endless complaints, the destruction of the city of Richmond, fires, businesses burned down and closed in the middle of COVID, and officers with COVID. Now we're talking about officers having the duty to act or intervene when we're scared to intervene because of the way the laws are going. Law enforcement was never consulted, to the best of my knowledge or anybody else's, to provide solutions or work with anybody to come up with solutions. Many LEOs are working without community support, particularly in urban areas, and destructive political rhetoric that we hear. Listen, we are here 24/7, 365. We will leave opening up our Christmas presents with our children to assist anybody. Since May 25th, the date of Minnesota's death of George Floyd, officers in Virginia have continued to answer calls for service, providing CPR, Narcan, processing homicide scenes, working fatal crashes, catching robbers and burglars, arsonists and rapists. Virginia LEOs do not deserve punitive actions to open the floodgates and allow frivolous lawsuits. And lastly, I ask every member of the committee, would you want to become a police officer, or would you want your child to become a police officer now? And if that answer is no, we really need to re-examine where we're going. Thank you, Mr. Chairman.
Thank you. Maggie DeBoard. Maggie DeBoard.
Good morning, Chairman. Thank you. I'm going to be very brief so I can give my other chiefs time to speak as well. The Virginia chiefs adamantly opposes this bill. I do not want to hit the points that our other LEOs have made at this point, but I will say this. There's a big difference between the job we do and those who carry liability insurance, like doctors and defense attorneys and others. We can't walk away. We cannot choose not to answer a call despite the personal risk or liability that we face every day. We have to handle those calls. And there's a huge concern with the passage of this bill that anytime we put our hands on somebody and somebody gets hurt, and that is bound to happen in the bad encounters that we typically have, we can't avoid that all the time. We can't do our jobs effectively with unnecessary lawsuits hanging over our head or an officer hesitating or worrying about what might happen in an encounter. Proactive policing, where it is needed most in our jurisdictions, is largely going to disappear with this bill. And as has already been said, it is disappearing and has been disappearing over the past year due to the anti-police sentiment and rhetoric that's been passed. We do have a mental health crisis in our profession, and it is growing every day. The passage of this bill will only exacerbate that. Lastly, I do want to say that you did some very good things by passing some bills in the special session that have increased accountability on not only us as law enforcement officers, but on our leaders. Let these new laws do what they're intended to do. It will hold us more accountable while still providing us the legal protections that we not only should have, and I would argue that LEOs are the exact people in that code that need to have those protections due to the quick decisions they make, but also the legal protections that we deserve to have for doing the job that it is very difficult and is largely unwanted by the general public. Thank you.
Okay, thank you very much. Ryan Zudema.
Thank you, Mr. Chairman. I'm Ryan Zudema. I'm Chief of Police in Lynchburg, and I appreciate the time. I won't repeat like Chief DeBoard said everything else, but I base my opposition to this on 24 years of law enforcement experience here in this Commonwealth. This bill would be detrimental to law enforcement officers, to departments, to local governments, and the communities we serve. Bottom line, this is a recruitment and retention issue 100%. For some perspective, we have seen in Lynchburg in the last 10 years an 83% decrease in applications to become police officers. We've seen over a 30% decrease in just the last calendar year from 2019 to 2020. We believe that this bill would be passed, it would have a ripple effect through our communities. We think crime would go up because, as you've heard, proactive policing already is going down, and this would decimate proactive policing. This is going to drive away the good men and women who are already in law enforcement now, and it's going to discourage new officers from coming into law enforcement at a time when we need new officers more than anything to come out in our communities, engage with our communities, partner with our communities, and support some of the change that we are all seeking, I think. Obviously, it's been said, but officers do not have absolute immunity. They can be and are held liable every time they step out there if they're violating a clearly established constitutional right. And we just see this as a bill that is going to be detrimental to law enforcement overall. It's going to be extremely costly to localities. It's going to not allow us to do the job that we need to do in the community, again, now more than ever. It's going to create frivolous lawsuits in our justice system that is already so far behind keeping up with cases because of COVID things. So we're 100% against this bill. We would ask that you not vote in favor of it. Qualified immunity is certainly not there to protect against criminal conduct. We hold our people accountable when they step out of the line. I thank you for your time.
Okay, thank you. Next, anybody else want to speak?
John Clare, please unmute and go ahead.
Thank you, Mr. Chairman. My name is John Clare. I'm the Chief of Police of the town of Marion, and I also represent the Virginia Association of Chiefs of Police, and I'm a third-generation police officer. I first want to say that I appreciate Senator Sorbell's categorical limitations compared to some of the more broadly worded language that we've seen in other bills. In a vacuum, these seem like reasonable limitations on immunity and a justifiable cause for action. And as a conscientious police officer, I empathize with that intent, but we don't live in a vacuum. In the last week, during Senator Reeves' requested language adjustment to the bills in 19283, language which to us seems somewhat nebulous and problematic, the response was that we don't want to change a bill before it goes into effect. We want to see how it turns out. I can tell you that no law enforcement officer wants to see how it turns out when they're held financially liable with almost limitless exposure. No reasonable person, especially a police officer, making decisions with very little information in very short time periods, can be held to a standard that evades legal definition, no matter how conscientious they may be. And if I could just end with this quote from the U.S. Supreme Court in paraphrase that says, "A policeman's lot is not so unhappy that he must choose between a dereliction charge if he doesn't act and financial damages if he does." If bills like this pass, the policeman's lot will in fact be that unhappy. And I would urge you to vote against the bill. Thank you very much for the time.
Thank you very much. Somebody else want to speak? Yeah, Era, go ahead.
Good morning. My name is Ara Trambley, and I'm here speaking on behalf of VEDA, the Virginia Association of Defense Attorneys, about concerns about this bill. First of all, we're not sure why the bill is necessary. Virginia has a common law battery action that's been used successfully to challenge police officers in deadly force cases. There was a very recent, very large verdict in Northern Virginia on a battery claim in a wrongful death case. There are established standards and common law defenses in a battery case. Sovereign immunity is not a defense to a battery claim, so we're not sure why this additional cause of action is necessary. Second, these new conduct standards that have not even gone into effect yet are different from established Fourth Amendment standards for use of deadly force. They're brand new. It's not clear to me that all the police departments and sheriff's offices have trained all their officers in these new standards, yet without knowing that these standards have gone into effect and the officers have been trained, this creates a cause of action for violating these standards. The way the standards are written right now, the remedy is use in a disciplinary proceeding, and if there are issues in the way police officers were trained by their departments in these new standards, that can be a factor that's dealt with in a disciplinary proceeding. But in this civil cause of action, it's not very clear what the standards are or how that kind of deficiency in training would affect the civil liability. The problem is this bill doesn't set up any standards or defenses to know how the case brought would turn out. I wanted to comment one thing about attorney's fees. It was stated by somebody that this is just like Section 1988 where there are attorney's fees, and it's actually not the same because under this bill, it's a one-sided bill. Attorney's fees are only available to a plaintiff who wins. If a police officer prevails in a case, he's not provided with the remedy of attorney's fees in this case. One thing I've heard from police officers is they're interpreting these bills as a requirement that they have to wait to be heard first before they can do anything. And one of the purposes of these standards was to get officers to report if they see another police officer acting in an inappropriate way. And I'm concerned if there's civil liability in addition to a disciplinary proceeding, that would have a chilling effect on police officers doing so. Thanks very much.
Thank you. Mark Dix, I believe.
Good morning, Mr. Chair, members of the committee. Mark Dix on behalf of the Virginia Trial Lawyers Association. We support the bill. With all due respect to my colleague from the VADA, this is about holding the employing agencies accountable in the most egregious cases. If we're going to prevent the next George Floyd, we have to have the employing agencies held liable in these type of situations, and consequently, we support the bill. Thank you.
Thank you. Dominique Martin, is that right?
Yes, that's correct. Thank you, Mr. Chair and members of the committee. We support, Dominique Martin, Policy Analyst, New Virginia Majority. We support this bill. We thank the patron for addressing the issue of qualified and sovereign immunity. We believe that these measures will increase accountability amongst our law enforcement. We know that qualified immunity has been subject to criticism by our top Supreme Court justices in the nation, saying that this can create precedents that say officers can act with impunity. We believe that people should be able to have their day in court if they believe that there has been some legitimate mistreatment given to them by law enforcement. And so we just hope that you guys can continue this discussion, pass this bill, and help improve relations between law enforcement and our community members by showing them and signaling to them that there is legitimate action for those who do feel mistreated by law enforcement. So thank you.
Okay, Phyllis Arico.
Thank you, Mr. Chair. Phyllis Arico from the Virginia Association of Counties. I associated our remarks with those of that are opposed to this bill. One of the reasons sovereign immunity and qualified immunity exists is that as one of the most important core functions of our communities, law enforcement has the largest exposure to litigation and other frivolous litigation. And so these reasonable immunities should not be eroded. I also just want to comment on, because this bill applies to the primary employer, which is going to be the localities, or the sheriff and the localities pay for their insurance, it's going to have a huge chilling effect on providing law enforcement to community and business and any kind of secondary type of law enforcement protection. Thank you.
Thank you. Anything else? Anybody else have anything you want to say? Michelle Gowdy?
Yeah, Michelle Gowdy with the Virginia Municipal League. I just want to thank the senator for being willing to talk to our group about this proposed legislation. We obviously would ask that you do not pass this legislation this year and that we continue to talk about it. You've heard all those reasons from our law enforcement and how strongly they feel about it and the effects on the localities and the financial effects especially. So we would ask that you oppose this bill this year, and we look forward to talking with the senator.
Okay.
Mr. Chair.
Yes, Senator Peterson.
Yeah, I'd like to make a motion, speak to the motion. I'm going to move that we pass this bill by, and I think the right place is to refer this to my subcommittee on civil laws. These do have to do with civil causes of action. And just as we're going to take a look at some other substantive issues, we can certainly take a look at this one. I tend to agree with the folks that said, you know, we passed such comprehensive criminal justice reform last summer, and those those laws are just now coming online, and we don't have really any standard of conduct. Plus, there are all sorts of indemnification issues and protection for folks, not just civilians who need to be protected, but also law enforcement personnel that are accused and have a right to defend themselves. So I just think that this bill needs a lot more time than the time we're giving it right now. So I would make that motion to PBI.
Mr. Chair.
Senator Deeds.
I would just ask Senator Peterson if he doesn't think that it makes more sense to create a joint subcommittee with the House Courts of Justice Committee to try to review this issue. My understanding is the House Courts of Justice Committee referred a similar bill to the Crime Commission, but of course, this is a civil action. Doesn't have anything to do with crime.
Right. I would be happy to work with the House. I'm not quite sure why they referred it to the Crime Commission. This has nothing to do with crime. This is not 18.2.
I would just hope that the chairman of this committee can reach out to the chairman of the House Committee and see if you can get a joint subcommittee formed to review this issue.
Okay, but right now we have a bill to pass the bill by indefinitely.
Mr. Chairman, question?
Yeah, Senator Morsi.
I'm inclined to support Senator Peterson's motion, but I do have a question of him. Because so many people have been involved and have spoken pro and for and against this bill, your request that this bill be moved to civil sub is not a suggestion or even a leaning on your part that you believe that Senator Servill's bill has no merit. Is that correct?
No. In fact, ironically, I was going to draft a similar bill last summer, but found that it was a much more complicated subject than I was able to sort of put together last summer. The Civil Laws Subcommittee just simply reflects the fact it's a change to the civil law in terms of perhaps putting together a joint task force with the House. I think that makes all the sense in the world, and I'm happy to be part of that. Again, I think the Crime Commission is the wrong venue for this. This is a civil remedy. So at this point, my motion is to pass by, but with understanding we will study this issue spring, summer, in whatever venue the chairman chooses.
Okay. A lot of this has to do with sovereign immunity, by the way. Okay, so the motion has been made to pass the bill by indefinitely. All in favor of the motion?
Mr. Chairman?
Yeah, Senator, who's this?
Right.
Oh, yeah, John.
Just a clarification. It's just to pass it by so that you can refer the bill to the Civil Law Subcommittee, is my understanding. Passing it by indefinitely will kill it.
Well, this is, I think the motion is to pass it by indefinitely. If in the future we want to send it to some other committee or something, we can do that too. Yeah. What is the motion? Motion to pass the bill by indefinitely, I think.
Mr. Chair, you could write a letter or you could create a joint subcommittee.
Mr. Chair, I'd like to ask that we do create some sort of a subcommittee. We pledged in the special session that we would deal with this issue, and I understand it's complicated. It's probably not going to get resolved today, but I do feel that it is our responsibility to take a really deep dive on it and address the challenges that people have brought forth.
Well, then the motion would be from Senator Peterson to refer the bill to his Civil Law Subcommittee.
Mr. Chair, may I ask a parliamentary inquiry?
The motion he made is pass the bill by indefinitely, which kills the bill, okay? Then
Wait, parliamentary
is
inquiry?
that the motion? What is the motion? Yes.
Parliamentary inquiry, Mr. Chair.
Yeah, Senator McClellan.
I'm trying to understand what John said. If the bill is PBI'd, can it be referred to a joint subcommittee, or does it need to just stay in the breast of the committee in order to be referred to a joint subcommittee?
PBI would kill the bill. One option I have put on the board is to PBI with letter.
Right.
A letter to the Civil Law Subcommittee.
That's what I was seeking clarification on.
Okay.
Right, Mr. Chairman.
Yes, Senator Servill.
Right, and I don't think that a committee of this body has to officially have a bill in front of it in order to have a meeting and talk about concepts or talk about some words on a piece of paper that's in front of them. So, I mean, this process discussion is interesting, but I think that Senator Peterson's subcommittee can meet anytime after we're gone. We can put this piece of paper in front of us and we can talk about making changes to it for when we next gavel in.
The motion is to pass the bill by indefinitely. Is that correct?
Yes.
Is that your motion, Senator Peterson? Okay.
Yes, sir.
All in favor of the motion, vote aye. All opposed, vote no.
Senator Norman, how do you wish to vote? Ayes 9, noes 5.
Ayes 9, noes 5. The bill has been passed by indefinitely. That doesn't mean we can't have a Civil Law Subcommittee look at the piece of paper at some point. Okay? Everybody clear?